my lord. Genealogy is that the Rangnath was the Karta Purusha of the family, having two sons, Vaman Rao and Sopan Rao. Sopan Rao died in the year 1965, leaving behind the Kausalya Bai widow and Parvati Bai daughter. However, the Vaman Rao was having a son, Shivaji. Well, in 1965, Sopan Rao died. In 1973, Kausalya Bai adopted the Shivaji when he was 6 years old at that time, and adoption deed was executed. Shivaji was the real nephew of Kausalya Bai. My lord, in the year 1974, on the application of Kausalya Bai, mutation entry number 293 was sanctioned in the name of Shivaji. At that time, he was minor, just 8 years old, showing him owner of the suit property, and Kausalya was shown as the guardian of that minor. Well, in the year 1995, for the family necessity, the petitioner had executed sale deeds of area 2 hectare ATR to the present respondent number 224 by the consent of Kausalya Bai and Parvati Bai. My lord, the marriage of Parvati Bai was performed after the 1995. My lord, he must be around 25 years old.
No.
Yes. My lord, in 73, he was 6 years old.
Yeah, so he is 67 born.
26,
So he was around 28.
28 years old.
Yes.
The marriage of Parvati Bai was performed after the adoption, but not in the year 1995. It must be around 80, my lord. So this is wrongly placed at this place, my lord. It should be prior to that. 2009 till the 36 years of the adoption, the present petitioner was functioning as adopted son and taking care of the family. Till that time, nobody raised any objection. First time in 2009, Kausalya Bai and Parvati Bai filed regular civil suit number 192 of 2009, seeking declaration of ownership and recovery of possession of the suit property. The present petitioner, being the defendant number 1, filed his written statement that he is an adopted son of Kausalya Bai. Since Kausalya Bai died during pendency of the suit got amended. The learned trial court partly decreed the civil suit by giving half share each to Parvati Bai and Shivaji, and affirmed that Shivaji is the adopted son. Being aggrieved thereby, Parvati filed regular civil appeal number so and so, claiming entire property in her share. Shivaji had filed cross objection. In the year 2020, the learned district judge allowed the regular civil appeal number 149 of 2014, and entire property was given to the share of Parvati Bai and no share was given to Shivaji. At page number 156, the finding recorded that the Shivaji is adopted son. Page 60, the first appellate court hold that there will be 3 class 1 heirs to share property of Sopan Rao. So Shivaji got half share is not understandable. During pendency of the first appeal, decree of trial court got executed and half share was allotted to Parvati Bai. In 2021, the purchasers, that is the present respondent number 2 to 4, filed second appeal before the Honorable High Court. The Honorable
Now,
High
how
Court,
did he hold 3 class 1 here?
my lord, according to him, my lord, the relation back theory he applied when the adopted father died. While there were 3 legal heirs, the widow, daughter, and me. But however, he said that
But on the date of the suit, pending suit, Kausalya Bai also died. No?
died.
Yes.
Thereafter, obviously, the trial court right.
So,
Therefore, the trial court said that since Kausalya Bai died,
No.
you 2 people, the daughter and adopted son, are the legal heirs of Kausalya Bai. So the property should be divided equally to
then again it comes to half only.
half. No, the trial court said so. The High Court has not, first appellate court has not given a proper reasoning. Just
So
one.
the High Court held that half of how you will get half, Parvati Bai will get half.
So
No, High Court is saying, let me.
That's how.
Honorable High Court is saying that the adopted son having no right in the property unless the family purchase any subsequent property. The adopted son having no right in a property already vested with the legal heirs of the that deceased Sopan Rao.
Was it decided without notice to him?
No,
Yes.
what happens is this. He was not noticed, but who had filed a second appeal? Second appeal was his purchaser. He had sold some share, 1/4 share, to purchaser. So they
No,
alone,
whatever it be, he was a necessary party.
I understand, but what happens is that portion was protected. So whatever he has sold 1/4, so he was not aggrieved. He did not file a second appeal before the High Court. So the purchasers filed, and purchaser's second appeal is allowed. So 1/4 share which he sells has been protected, though purchasers have been protected. He does not file a second appeal against the
So
judgment.
you are for the purchasers.
Sorry, Mula?
You are for the purchaser.
No. I am for
For
the
Parvati Bhai.
Parvati, sister.
Parvati Bhai.
Yes, what happens is this. Since the sister gets 3/4 share, his vendor, he sells it to the second.
He gets 1/4.
1/4.
So that 1/4 is also gone to the purchaser.
Yes. That time
He gets 0 now.
He gets 0 now. So he doesn't file a second appeal.
Without hearing him,
But-
and when he was a party, without notice to him, how could he have
I quite see that.
unknown procedure?
I quite see that. But my lord, he does not file a second appeal. So
Whatever it be, but is he not a party to the second appeal?
right, that he was
Party.
So it has to go on that short ground.
so my lord,
Another
Even notice is not issued.
notice is not issued.
In a second appeal, notice is not issued. The question of law is not framed.
framed in the dictation
My
of
lord,
in order.
it is
That was not framed earlier.
What happens is
Not
this,
framed in
this
the
is the accused judge. So High Court in fact protects the purchaser. He doesn't get, even otherwise he doesn't get. My lord.
No, that's a different matter, whether he would have got it or not.
Because after 1956 Act, Hindu Adoption and Succession Act, and after Hindu Succession Act, since Section 6 Clause 3 says that the partition opens after the death of the co-partner. So there,
In the partition suit, there are no plaintiffs, no respondents. You should have been noticed.
Not a suit for partition.
No, it has turned out to be in substance.
Yes, if your lordship sees page 65, the prayer, this is for declaration of ownership and recovery of possession. So this was not a suit for partition as per se.
Correct. So he set up adoption.
Yes. Page number 85 are the prayer.
No, he set up adoption, no? He set up adoption as a defense. Now, thereafter,
Where is the question of law?
At page number 5, while the time of
Page 5,
dictating
page
the
5.
warden.
Page 5, para 10. Whether the principle of relation back is applicable to the present case in view of section 12 of Criminal Justice. So that is the prime question on which the
When was this question of law framed? You're asking. You have recently deprecated such practice
yeah,
of Nagpur bench. I think 3-4 months back, most probably Justice sitting with Justice Mehta.
that's true. I don't know whether it was framed earlier and then it was incorporated in this order. That I need to
he
find
says
out.
it was felt during dictation of the judgment.
Well, that doesn't seem so from the order, but I had to find out if it was framed earlier and then it was
I'm
just
sure that I have gone
incorporated.
through the entire orders on record.
I had to
No
find
such
it out.
error.
But
And your lordship
none
may kindly see that within 21 days the
Password करके पूछने दो मुझे
If your lordship sees the
Second appeal of 2021 decided in 2021.
within 21 days of the first hearing.
Don't notice.
since it was a short question of law.
The principles of natural justice are not applicable to the High Court.
I quite similar something which was decided in his favor. He has challenged it.
The appeal deserves to be allowed on the short ground that in a second appeal, that the second appeal, wherein the present petitioner was respondent number 2, was decided even without giving notice to the petitioner. The DAC further submit that even the question of law which were framed by the learned trial judge were framed during dictation, and the appellant, the petitioner, did not have an opportunity of being heard. Such a practice by the High Court is deprecated by a recent judgment of this court. देख लेना वो second appeal का है अब नहीं है. Most probably justice just take it. The appeal, the impugned order, therefore cost and set aside. The matter is remitted back to the High Court for deciding it afresh in accordance with law. Very good. Since the appeal arises out of a suit filed in the year 2009, we request the High Court to decide the appeal on merits. We decide the appeal expeditiously.
May I request for some
Preferably within a period of. There is a judgment by now coordinate bench that we should not issue such direction.
if we can request you.
Because I could decide it as quickly as possible and preferably within a period of 1 year from today.
I'm so glad.
Well, notice has to be issued because I am accruing the right to file cross-examination only after.
That is what we have held.
But notice has to be
The notice will be now issued.
No, notice has to be issued to me because.
That is what we have held. We are allowing your appeal on that short ground that it is heard without notice to you.
Mr. Atul, order is because no notice issued, remanded. Now notice will be issued within 30 days of you file that whatever.
Cross-examination. 30 days, sir. I'm grateful. I'm so glad.
Item 10, the matter arises from an order of the NGT whereby environmental cost damage was imposed on the appellants before your lordship, basis reports which had categorically said there was no environmental damage. Your lordships were pleased to injunct any coercive steps against the appellant for recovery with a order dated 2nd of February 2023. The matter is coming up for the first time after that. In the meantime, your lordship, there was also a direction in the impugned order, para 51 at page 89, where the tribunal had itself noted that the environmental clearance applications of the appellants have been pending with the Environment Authority, SIA Gujarat, for a long time. And SIA was directed to proceed with those applications. Now, when we presented those, that aspect of the impugned order has not been challenged by anyone. We've only challenged the imposition of damages. Now, when we presented those applications once again before SIA, your lordship, that aspect is in IA 55293 of 2024, which is listed before your lordships. We have said, your lordship, that SIA has deferred the consideration of those applications on the sole basis that this matter is pending before your lordship. Which, your lordship, lordship, that's on record, lordship, is mentioned in the office report. That's IA 55293.
Admit करके रख देते कुछ लोग.
Tantabag judgment.
Lordship, please. Where
It should be sent back also, we can decide.
that is in so far as the committees were framed
Your application before CA is pending for what?
for grant of environmental clearance. And if your lordship could just have page 5 of the application for a minute, I've extracted the relevant part of the impugned order.
This is about mining activity.
Your lordship, please. This is for limestone mining.
Notice has gone in this application.
Notice has gone. Some respondents are unserved. The union, I'm told by the office report, has filed a counter, is not being served on us. It's in defects.
Who is appealing for the union? I think this party was here some time back.
Our difficulty is that despite the impugned order saying that the EC application should be processed, that's not under challenge.
वो consider करने के लिए बोल देते हैं. (293) of 2024. By the order impugned, the NGT had directed the SIAC, State Environmental and Long Form,
Lordship, please.
to decide the application made by the present petitioners for grant of environmental clearance.
That said 2 months. They had said 2 months, decided within 2 months. It's been 2 years.
It was directed to be decided within a period of 2 months. 2 months. Very good. The I has been filed by the petitioner, pointing out that though there was a direction by the NGT to decide, to the CA to decide the application for environmental clearance within 2 months, the same is not decided on the ground of pendency of the SLP. Paragraph. The SLP only challenges that part of the order by which costs have been imposed upon the present petitioners. Insofar as the direction with regard to consideration of the application by CI in a specific period, no party has challenged the same. We therefore allow the application and direct CI so and so to consider and decide the application filed by the present petitioner for grant of environmental clearance as expeditiously as in accordance with law, as expeditiously as possible, and in any case within a period of 3 months from today.
Of cost will say, one thing.
Lordship, CI is respondent number 3 before your Lordship in this matter.
Can I respond number 3 CI? Interim order to continue with them.
Lordship may kindly observe that the CM, your Lordship has said in accordance with law, uninfluenced by the pendency of this matter.
And we already clarified.
Lordship, please. Lordship, we may be permitted to complete if your Lordships are admitting the appeal.
Yes.
Lords, may I make one request, Lords, on behalf of respondents number 15 and 16, Lords.
Okay, Gujarat State Environmental Impact Assessment Authority. 15 and 16, who are they?
Lords, they were also one of the parties, Lords, respondents before the NGT, and here also they are 15 and 16, Lords. The fact is, I have already complied with the order. I paid up the compensation, etc. Because on an assurance made by the SCA saying that they would consider my application for environmental clearance only then. So, Lords, I should also be considered on at least on this point, Lords. I've already paid the money because it's about 58 lakhs or so.
You are seeking relief in his IA.
I agree, Lords, but I'm saying I complied with the Lords. I complied with the order under the expectation, Lords, that they are going to grant the. Yes, Lords. Yes, Lords. I'll file a counter as well as an IA, Lords. Much obliged, Lords.
What counter you are supporting him, and what counter you want to file?
No, that's a formal counter. That's it. Nothing else, Lords.
I can't say pleadings may be completed because.
In the meantime, the parties to complete pleadings.
I'm very grateful to your Lordship.
Lordship, this is a writ that was preferred by the victim in the Air India urination case.
No,
Lordship will
That
recall.
is 11.
The prayers are set out at page 23. Now the DGCA has filed a counter. What we had essentially asked were protocols to be put in place to deal with unruly passengers. This was basically motivated because the victim that had gone through the trauma put by the crew of Air India is what she doesn't want other citizens to suffer from. So now the DGCA has filed a counter saying that everything is in place. But we have gathered some international practices and we have made some suggestions if the DGCA could look into it and come back.
Give a suggestion to.
Difficulty, but our protocol is amongst what is the international.
Best.
Is that in our affidavit, but there's no harm in.
What are the suggestions?
Protocol gets revised every.
Let us see the suggestions.
Please.
It's regarding accountability of the crew as well, Your Lordship. Because the passenger who's been in the plane for 12 hours or even more on international flights.
Particularly senior citizen. She was 73, I think.
Absolutely, Your Lordship. She was not offered an alternate accommodation. There were seats empty in the business class. She was made to sit on the same seat. She was, in fact, the perpetrator was sent to her. She said that I don't want to settle. The crew insisted that you settle the matter. The FIR was not lodged by the crew. This is the responsibility of the airline, Your Lordship.
Whereas in the instant case, actually the notice was issued on guidelines, but in our affidavit, we have also placed on record what is the action that has been taken. Page 5, if my lords will have of our affidavit. There is an imposition of financial penalty of 30 lakhs, my lords, on the airline. there is a suspension of license of the pilot in command in the instant case. So we have pointed out in our affidavit the.
So how do you check passengers who get in with intoxicated?
So Malaz,
This was an international flight.
this was an international.
New York to Delhi.
Flight में भी तो क्या करेंगे?
No, that is my question because we had a recent experience, me and Brother Justice Suryakant sitting on the other side. Two passengers fully drunk. One got into the washroom, slept off. One outside with the bag to vomit, given by the all women lady crew. Half an hour, 35 minutes, they couldn't open even with the master key because it was an all women lady crew. They requested my co-passenger, the male member, and then he opened and then to wake him up and get him out to the seat. 2 hour, 40-minute flight sector. I'm taking as late as 15th September. As late as 14th September, late night.
The problem is that.
I can't comment on that, Malaz, but I can only place the guidelines which are in place. There would be aberrations, Malaz, and action has to be taken for cases of aberrations.
The guidelines with respect to what happens after the incident are in place. What is the crew to do when such incidents take place? How are they to be sensitized, especially when they're dealing with the senior citizens? We are confined in a space. We can't just, there's no door that we can just walk out of. There are 188 million passengers that go through 132 airports in India daily. That's a big number. So we need some stringent guideline that this incident doesn't happen to. I'm sure it can happen. I'm just saying that the crew needs to be sensitized on what needs to be done. For example, in
Just
the US.
look into the suggestions if you.
Yes, Malaz, no difficulty.
It's not an adversarial.
You also come out with something how to regulate this.
Please,
As a brother says, if it is an international flight, etc.
Please, Malaz.
An entry may be controlled, but what about somebody?
Yes, Malaz. So, Malaz, guidelines are in place. SOPs are also there, Malaz. I'm not saying that there will not be cases of aberrations. In this case, stringent action has been taken. Other cases that are reported of aberrations, also action is taken. So, the guidelines and SOP by airlines individually are also in place. But there is no, it's not adversarial. I bow down. We look into the suggestions. These are protocols that get revised every year.
For senior citizens, seating, strategic seating or whatever.
Please, Malaz.
Something creative.
Please, Malaz.
The learned ASG. The present petition has been filed by the petitioner, seeking directions to the respondent number 2 as well as various airlines as to lay down guidelines to control unruly, disruptive behavior of the passengers. Very good. This party, the learned ASG, states that the respondent number 2 has already, what its guideline or SOP?
Well, there are guidelines and my lord's circulars.
Has already.
SOPs are by the airlines.
Has already notified the guidelines, so also issued various circulars to control the unruly behavior of the passengers. It is submitted that the guidelines also take care of fixing the accountability of the crew. In addition, it is stated that the airlines also have issued standard operating procedures for controlling the unruly behavior of the passengers. Paragraph. The learned counsel for the petitioner has given certain suggestions by collecting a data of the guidelines issued by various foreign jurisdictions. Paragraph. We request the learned counsel of the petitioner to hand over the same to the learned ASG so that the learned ASG can instruct the respondent number 2 to examine the same and find out as to whether the guidelines could be modified so as to make them more comprehensive. After 8 weeks.
Logic.
Yes.
Finance, the state officials are before your lordship's finance. This is contempt proceedings, finance. And it is our respectful submission, finance, that the order has been fully satisfied, finance. I'll just, finance, place a few orders for your lordship's kind perusal. Finance, the impugned order entertains, though on jurisdiction, the impugned order actually entertains, finance, an appeal in a contempt matter, which is otherwise not permissible, but I will show to your lordships how the directions in the main matter itself, the original directions, have been complied with. Yes, they have been complied with. I'm showing that we have, I'll just place my case in 5 minutes, my lords. My lords will find the original order is of your lordships, my lords, at annexure P4, page 68, my lords. Starts at page 68, and if I can take your lordships to the directions at page 81, foot of the page, my lords. I'm not going into the, my lords, maintainability or otherwise of the appeal against contempt because it's your lordship's order. I just need to show to your lordships that the directions have been satisfied, my
But
lords.
the issue is not the compliance of your lordship's order. The issue is
Let us place our case. We will not be passing any order without hearing you. Yes.
Lords, may kindly have page 81, my lords, foot of the page. These are your lordship's directions.
Direction number 3.
But direction number 3, I'm grateful, my lords. This is what we are relying on. Your lordships when said that direction in para 63(1) is confined to the 10 teachers presently remaining with the appellants, though the appellant society shall at the earliest settle in accordance with law, if not settled so far, all dues to other teachers who have left the institution in the meanwhile. So, my lords, it is our case that she does not fall in these 10 teachers who were continuing, and therefore we were only required to settle her dues. This is our respectful submission, my lords. Now, kindly see, my lords, the contempt petition when it was filed. Now, kindly see her case. Her case, my lords, is decided by a separate order at annexure P7, page 89. Starts at 89 and 8 page 95, my lords will see.
But it says it shall also settle other teachers.
Yes, so my lords are at 83, my lords?
No, the same direction 3.
Yes, my lords.
Confined to the 10 presently remaining, though the appellant society shall at the earliest
Settle in accordance with law.
accordance with law.
If not settled so far, all the dues.
Use.
So the dues had to be settled for anyone who was apart from these 10 teachers who had continued in service, my lords. And my lords, the direction in her case.
Who have left the institution in the meanwhile.
Yes, my lords, because these were teachers, 10 were continuing, others had left. So we were directed to continue 10 and directed to settle the dues of the remaining. My lords, her case came to be disposed of at page 95. My lords will see the directions to be treated in accordance with your lordship's judgment. So that's the only case, direction in her case by the High Court, that your lordship's directions have to be complied with, entitled to the same terms of the order of your lordships, my lords. Page 95, foot your lordships will see. Now kindly see, my lords, when the contempt is filed, my lords, she submits representation and we pass a speaking order at annexure P13, my lords. That starts at page 113, and at page 116, your lordships will find. May I just place this one paragraph at 116, my lords, foot of the page. After the shutting down of UP board branch of the Calvin Talukdar Inter College, the applicant worked on the post of PGT Physics from 2005 to 2007 at Rani Lakshmi Bai Memorial School. That's another school. Thereafter, applicant is working from 2007 April till date at Rani Lakshmi Bai Memorial School on the post of PGT Physics. Applicant is continuously employed at Rani Lakshmi Bai Memorial School since 2005. As per information received from Rani Lakshmi Bai Memorial School by letter dated so and so, applicant is presently receiving a salary of 74,000 so and so per month. In this manner, Srimati Davina Tiwari falls in the category of teachers who have left the school. Hence, she cannot be given joining and paid salary under para 30 Roman 3 of the judgment of the Honorable Supreme Court. And Malats, from the para 5 Malats, from the above information provided by the District Inspector of Schools, and after careful consideration thereof, it was found that after termination of her services from the school in question is continuously engaged with this another school since 2005, drawing monthly salary. Consequently, in view of applicant being employed at so and so, no occasion for her to be appointed and paid salary at so and so. Then, a contempt petition is filed at annexure P15, page 125. And it is noted, our speaking order is noted, Malas, at page 125, 126, Malas. The single judge in the contempt proceedings, Malas. The directions of your lordships are quoted in para 4 at page 125. And just one paragraph, if I can place at 126, which is noted as an admitted case. Para 5 at page 126, may I please, Malas? It is admitted case of applicant that she is not a teacher amongst those 10 teachers who have been referred in the aforesaid judgment. In the counter affidavit of state, it has been stated that applicant is teaching in Rani Lakshmi Bai since 2005. Therefore, her claim is not covered under the judgment referred herein. Malas, the impugned order is an appeal from this judgment. Where, Malas, lordship will kindly now see page 2, Malas.
Is her claim for salary or for the dues?
Joining. She wants to join the school.
Join the school.
And for salary.
Only for 10%. Appeal case are terrible. Only if they would have.
Where do we say that?
But enable.
That's it. Lord, with due respect, that's the only issue with your lordships, Lord.
No, that may be the only issue, but that goes to the jurisdiction. How is appeal tenable?
That's what
Had they been held guilty?
lordships may, Lord, as per your lordship judgment in Midnapur itself, Lord, I am covered, and the rule 5 of the High Court rules, Lord.
Midnapur is SLP. They say, this is Ravindran's judgment, I think.
No, Lord, it says, well, speaking
Where-
judgment, Lord.
Any other order will be, no.
It is quoted, Lord.
In excess of the contempt jurisdiction.
In excess of.
In excess of the contempt jurisdiction.
Yes,
Any other order in exercise of the contempt jurisdiction.
yeah, that's right, Lord. The order, against which I made the special appeal, that is the contempt.
No, that is an order exonerating them.
No, Lord, I am sorry, with due respect, Lord.
No,
No,
that-
this could have been under section, your appeal must have been under section 19.
So rule 5 of the High Court rules, Lord. Lordship may see the Midnapur first, Lord, they have already quoted in the synopsis only. Lordship may see them.
No contempt is made out, so it is a refusal to exercise the contempt jurisdiction.
That's why the appeal is maintainable, Lord, as per the Midnapur and the rule.
पता है मिदनापुर का है.
Yeah.
658. Page 399.
Already quoted in the page B, Lord.
Page B.
Page C of the synopsis, Lord.
3 SEC page.
399, Manas.
Page C of the synopsis is quoted.
Para 11, Manas. See.
Yeah.
Yes. The petition position emerging. Yes, please.
Roman 5, Lord. Roman 5 is my case.
Read from the position emerging from this
Yes,
decision.
the position emerging from this decision in regard to the appeal against the order in contempt proceedings may be summarized thus. First, Lord, an appeal under section 19 is maintainable only against an order or decision of the High Court passed in exercise of jurisdiction to punish for contempt, that is in order to imposing punishment for the contempt.
So this does not
It's not correct. My lord. Second, my lord, neither an order declining to initiate proceedings for contempt, nor an order initiating proceedings for contempt, nor an order dropping the proceedings for contempt, nor an order acquitting or exonerating the contempt is applicable under section 19 of the CC Act. In special circumstances, they may be open to challenge under the article
136.
It's not applicable in my case.
Why? It's an order exonerating them in the contempt.
Allow me to read further, my lord.
Okay, we read it further.
In proceedings for contempt, the High Court can decide whether any contempt of court has been committed, and if so, what should be the punishment and matter incidental thereto. In such a proceedings, it is not the appropriate to adjudicate or decide any issue relating to the merit of the dispute between the parties. That is my case, my lord.
No, so,
Contempt
but
proceedings.
what about tenability?
Yes, my lord, I am coming down, my lord. Roman 5, my lord. Roman 5 to locks me along the. Now, this is the case, my case is that they have adjudicated on merit which otherwise is not.
Where is the adjudication of merit? It only holds that there is no contempt.
I will show it, my lord, I will show it from the order itself. Lordship may allow me. Roman 5, if the High Court for whatever reason decide an issue or makes any direction relating to the merit of dispute between the parties in a contempt proceedings, the aggrieved person is not without remedy. Such an order is open to challenge in an intra-court appeal if the order for single judge and there is a provision for intra-court appeal that is there in the High Court rules, my lord. Or by seeking special leave to appeal under 136 and all. Under these provisions, my lord, I have filed the appeal. Now, lordship may have the contempt order.
So what is the provision for intra-court appeal?
Yes, my lord, rule 5, rule 5.
Where is that?
In my counter affidavit, my lord, I have quoted, give me the counter. Count my counters. Page 35, my lord, of my counter affidavit. 34, huh?
Counter affidavit is only 5 pages.
35 of my counter.
Oh, respondent 1 is it?
Yes. I am respondent number 1. First, may page 35.
Yes. What upload?
Page 35 of my counter. There is Rule 5 of Chapter 7, Chapter 18 of Miscellaneous Provision of Allowed High Court Rules so and so, special appeal. An appeal shall lie to the court from a judgment, within brackets, not being a judgment passed in exercise of appellate jurisdiction. That's my case, Lord. In respect of a decree or order made by a court.
So they like an LPA.
Yes, no, it's like an LPA that is permissible, my lord, and that's why we have filed. And we
Where-
are actually recognized in Midnapur as well.
Where is your appeal?
Yes. Special appeal is, Lordship may have it, is page 127. Lordship may have page 128. If Lordship may see 128. That's my heading.
128 of the
128 of the special
SLV.
paper. It starts from 127 at 128. Lordship may see your heading. Special appeal under chapter 8, rule 5 of the Allahabad High Court. Against the order part so and so, so and so. That's why specific appeal, my lord. And that's the only point they have raised. And with that,
Where is the decision on the merits?
yeah, that's why my lordship, not my humble, this is contempt order, lordship is in law page 125 of the petition below.
No, kindly see the special appeal is subject to the superintendence of the court.
That was allowed, my lord.
This is with regard to lower courts.
Lower court.
Just see the rule which you read just now. You read it carefully, Mr. Sanjeev. An appeal shall lie.
Of degree of so and so, appeals are like to the court of judgment in which size of
Sub-
appellate jurisdiction.
By a court subject to superintendence.
And not being an order made in exercise of revisional jurisdiction or in exercise
That's
of
correct.
superintendence and
That's
all.
correct, but subject to the superintendence of the court.
Right, my lord, that was the order passed by single judge, against which I filed a contempt. Contempt, the court adjudicated on merit. Then I filed a special leave under rule 5, my lord. Now they have challenged. They have not challenged the single judge order of 2015, my lord, which is an absolute now. They have challenged the interim order, saying that you please.
Won't apply to you.
And then Midnapur says.
But there is no adjudication on merits, or it only says that No contempt is made out.
That's what he has given, your lordship, may see 125 page, with due respect.
We have seen, yes.
Yes, 125, lordship, the earlier order was 14, passed by the single judge.
Is the single judge subject to superintendence of the division bench or subject to an appeal wherever provided? Single judge is not subject to superintendence of the division bench.
The lordship will not done. If you don't-
The order.
below,
Yes.
the original order passed by the single court as page 89 below.
Hmm.
So that was the subject matter of the content below.
There is no adjudication on merits, Mr. Counsel.
Lordship may have page 125 and then 126.
Yes, we have seen the both.
126, Lordship may see below para 5. He has adjudicated on merit. It is an admitted case of the applicant that he is not a teacher among those state teachers who have been referred to in the aforesaid judgment. In the counter affidavit of the state government, it has been stated that the applicant is teaching Rani Lakshmibai so and so. Therefore, her claim is not covered under the judgment referred to the record. That's a adjudication on merit, Lord, whether it is
Thank you.
covered or not.
Sorry, we have heard
Lordship may-
Bhatti, the learned ASD for the appellant and Sanjeev Kumar and Shri Sanjeev Kumar putting on behalf of the respondent.
My lords, my appearance may be marked for respondent number 6.
Lordship may allow the liberty to find a special petition.
And you will, you withdraw that contempt appeal.
I'll be
Anyway, we
You
will.
can withdraw. A successful party can withdraw.
Order करके उतना लिखता है and she so and so. Which party the learned counsel appearing on behalf of the appellant submitted that as a matter of fact, the appeal filed by the respondent challenging the order passed by the learned single judge dated 5th of January 2022 itself was not tenable. He submitted that by the said order, the learned single judge had held that the appellants could not said to have committed contempt of the order of the learned single judge, and therefore, in view of the decision of this court in Midnapur so and so, the appeal was not tenable. Per contra, the Sanjeev Kumar, the learned counsel appearing on behalf of the respondent, submitted that the respondent that the learned single judge, while deciding the contempt petition, has gone into the merits of the matter, and in view of clause 5 of the aforesaid judgment, the appeal was very much tenable. Paragraph. This court in the case of Midnapur People's Cooperative Bank Limited versus Chanila Nanda has observed thus. Page C. From the perusal of the order passed by the learned single judge, it is clear to us that by the said order, the learned single judge had in unequivocal terms held that the no case for contempt was made out of the judgment and order of the said High Court dated 22nd of April 2015, and as such dismissed the said contempt petition. As such, in view of clause 2 of the clause 2 of paragraph 11 of the judgment of this court in Midnapur, the appeal itself was not tenable. Paragraph. The reliance placed by the learned counsel for the respondent employee on clause 5, in our view, is not well placed. First up, there is no adjudication or direction with regard to the merits of the matter by the learned single judge in the order dated 5th of January 2022. In any case, in view of a specific bar, the remedy available to the respondent respond number, your
Respondent one.
respond one.
Is the
If any was to challenge the order of the learned single judge by way of an SLP on this short ground, we are inclined to allow the appeal. The impugned order is quashed and is set aside. The appeal filed by the respondent employee before the revision way of the High Court stands dismissed.
Great.
We already observed that
Limitation exclusion.
in the event the petitioner decides
Number
to,
one.
the respondent number one files an SLP before this court challenging the order of the learned single judge dated so and so, will be entitled to benefit of section 14 for the period during which the proceedings were pending before the revision bench and this court.
Great.
Very much.
The formal respondent measure.
would request for one more indulgence. Because the party is that they want to apply. Conservation in the input order which is because I'm involved on the other side.
We clarify that in the event petitioner applies for regular bail, the observations made in the impugn order would not influence the learned judge who decides the bail application.
Because usually detail use, the petitioner is.
The detail. Thank you. Inform the other side. Mr. Deshmukh is there.
Item 36, I have just informed Mr. Shivaji. 2 weeks.
Yours is 36 today.
36.
They are 37 tomorrow.
36. Here I have.
Okay.
I'm.
Jalgaon.
Jalgaon, that bank.
Yes.
Sorry for the first call, I was not there.
Yes, Mr. Rajan.
Yeah, we come back to your lordship's period. What has happened, the High Court has not really gone behind the two orders earlier passed by the High Court itself, firstly in the writ petition, then in the review, and the subsequent order which your lordship passed on my SLP, my lord.
Yes.
Now, what has happened is, my lord, the High Court, the first order, my lord, that's dated 22nd of March 2018, which your lordship will notice at page number I.
Yes, I filed the judgment in my, along with my counter. It can be seen at page 22, the full judgment.
Page.
Minutes, page 22, annexed to the counter,
23.
22 minutes.
Counter affidavit on behalf of
It
witness number
begins
1.
at page 21.
Yes, my lord. The
Counter
first-
affidavit on my behalf. At page 21, it begins.
Yes, Dilip Gupta and Shachi.
Yes.
Yes, sir.
Now, my lord, may I read that one? I'll be referring to three orders and then make my submission. This petition has been filed for a direction upon Noida to remove the encroachment made by over Khasra number 196, Gram Wajidpur, or in the alternative allot the same area of land since possession of the aforesaid land was taken by Noida without taking recourse to either acquisition or purchase. Petitioner claims to have purchased 4680 square meters of land situated in Khasra number so-and-so by a registered sale deed of 21st of June 2012. In para 26 of the petition, it has been stated that the land has been utilized by Noida without invoking the provisions of Land Acquisition Act 1894 or by private negotiation in total contravention of provisions of Article 300A of the Constitution of India. That land has been utilized, that is not in dispute, I will not dispute that. We have taken that. A counter affidavit has been filed on behalf of Noida. The counter affidavit does not state that the aforesaid land has either been acquired by the state for Noida or purchased by Noida. It is therefore clear that Noida has taken possession of the aforesaid 4680 square meters of land without any authority of law. The petitioner therefore clearly entitled to compensation for the aforesaid land. No dispute till this case. At this stage, it would be appropriate to refer to the government order dated 21st of March 2016, which provides for determination of compensation by a committee constituted under clause 3, small I of the aforesaid government order. We therefore consider it appropriate to direct that. The committee constituted under the aforesaid government order shall determine the amount of compensation payable to the petitioner within a period of 2 months from the date a certified copy of this order is filed by either of the parties before the collector, Gautam Budnagar. However, as Noida has taken illegal possession of the aforesaid land, we direct that by way of interim compensation, rupees 5 crores shall be paid to the petitioner within a period of 1 month from today. The balance amount, if any, shall be payable within 2 months after it is determined by the committee. If the committee determines compensation amount that is less than 5 crores, then the petitioner shall refund the same within 1 month. The writ petition is disposed of. Well, it is disposed of in this term. This part of the order is never challenged by respondents in the present assembly. Now what has happened? Not against the order passed.
Your challenge, your file a review of that.
Yes, both parties filed a review, my lord. In fact, at page 23, if my lord will have a look at, my lord, there are two review petitions which are mentioned, number 1 and number 3.
Yes.
May I read that? 2 review applications have been filed for reviewing the judgment and order dated 20.
They are rejected, so both are rejected.
And here again, my lord, what I would say, my lord, again, my lord, they have raised the issue whether the compensation is to be determined under the 2013 Act. Therefore, I wanted to not place that portion of the review order also. May I, Lordship, may I have the last 2 lines of page 23. Very.
Yes.
The submissions of the learned senior counsel appearing for the applicant is that land may now be acquired under the provisions of the Right to Fair So-and-so Act 2013. The submission was not raised during the course of hearing of the writ petition. In our opinion, once possession of the land has been taken, the committee can also determine the compensation to be paid to the petitioner. The possession of land is alleged to have been taken by Noida in 2013 and the writ petition was filed in 2017. Second review petition application is filed by Noida with a prayer for intent compensation may be reduced. The interest of Noida has been protected in as much as it has also been observed that if the committee determines no compensation amount to be less than 5 crores, then the same would be refunded. Now, Lord, against this order, my lord, we approach your lordship's. Page 116 of the paper book, Lord.
Page
116, Lord. Lord, this order is dated 12th of December 2018. The relevant portion is, having regard to the peculiar facts of this case, we direct the petitioner so-and-so to determine the compensation payable to the respondents in relation to land strictly in accordance with law within a period of 2 months from today. In the meantime, the petitioner shall pay by way of interim compensation amount of 2 crores. So, my lord, 5 crores is now reduced by your lordship's order, my lord, to 2 crores, and this amount shall be adjusted against the final determination of compensation once made by the petitioner. Then, my lord, a contempt application is filed, and the order disposing of the contempt petition is at page 124. This order, in my respectful submission, is relevant for the controversy which is now got to be raised again.
Yes.
Now, at page 125 is only a reproduction of the earlier order. I would not read that, my lord. I have already read that to my lord. Kindly come to my lord, page 126. That's the relevant order passed by my lords, my lord. Agreed by the aforesaid order passed by the High Court, Noida third respondent approached this court by filing SLP number so-and-so. This court reduced the interim compensation from 5 crores to 2 crores, and it was observed that the same shall be subject to final determination by the committee. But again, the word used committee, not under the act.
No, but the word used in the order is law, in accordance with law in the main order.
Again, because that is why in the review order, again, that act was mentioned and the High Court rejected. Now that order, in my respect,
But it doesn't say that it has to be paid under the old act or the new act. It would say
the
that.
committee will determine, because the committee is formed under the 2016 government order, that determines what the rate is going to be.
Committee is only the deciding authority of the amount. It has to apply the law in force. So all cases need not be contested. You may in your department, Mr. Ravindra Kumar, decide to pay strictly in accordance with law. So you form a committee, form multi-member committee, But pay in accordance with law.
With respect, well, I don't form the committee, nor I have any role in the committee. The committee is formed by the government under a government order, which is general in nature. Therefore, my lord, the lordships were of the view that you proceed under the committee in terms of the government order. That is why, my lord, here, my lord, we have heard so and so and so and so. It is not in dispute that an amount of 2 crores is already paid to the petitioner. The contention of Mr. So-and-so senior counsel is that negotiation committee, which is constituted as per proceedings dated 21st of March 2016, is not competent for determination of market value. And as such, market value as proposed by the respondents is not agreeable. It was obligatory on the part of the respondents to initiate proceedings under the Act 2013. Here again, that is taken care of. On the other hand, Shri So-and-so learned counsel appearing for respondent 3 has drawn our attention to the specific direction.
Taken position. Officers in persons to the orders passed by the division bench.
Lord, we have approached your lordship, Lord. That is for the state to take.
No, you have to do Department of.
And I'll just go back to the institute order.
You take somebody's.
That is right, Lord. I cannot, not standing here before my Lord.
The learned judges elaborately discuss about your conduct. Dismissed.
I'm only taking the committee pursuant to your.
No, thank you. To take somebody's valuable land without following due process of law. You take law into your hands.
I'm only saying something. Your lordship would grant me that which is done.
Yes.
And
Your stand that mighty's right should not be
no.
Made applicable.
Against the land which they purchased for 60 lakh, we have paid 2 crores 80 lakhs. That's the compensation determined. If, my lord, I make a submission. If they are agreed by the rate of compensation, they can proceed under that. Today, what has happened is, my lord, the orders passed by your lordship, my lord, rejecting this contention that you will proceed under 2013 Act. Lord, the High Court says you proceed under 2013 Act. That's my comment of my submission.
Thank you.
So any development authority can form a committee.
No, not it's by the government, no, not by me.
Or government, and say that notwithstanding any other act which will determine compensation, we will give this much amount.
Your lordships will not directed the committee to proceed, not me.
It's been dismissed. I'm not joining the issue, Millets. They misled this honorable court. They lied before this honorable court, and they invoked another provision instead of the provision that's been dictated by the High Court, because there they could pay the less compensation. Only when I file the contempt, then some other authority, without having any jurisdiction, passes an order and comes to this court and said, we have passed an order.
Yes, next matter.
Great.
Lordships, we have filed a detailed affidavit stating how we have complied with the order which Lordships had directed. The order is of 19th May 2004, which they alleged contempt, Lordships, before the High Court. And the High Court, on a erroneous assumption that there were certain other things to be complied with, after more than 15 years, 20 years, Lordships, it directs that certain more benefits have to come to them which have not been given by the state. Lordships may have the order which is 17th of October, 19th of May 2004.
Page?
Lordships page 69, annexure P3.
$69.
Yes, Lordship. Lordship, the issue here, what had happened was they had filed writ petitions in the year 1993-94, seeking a relief that we should be appointed and we should be regularized. They were working as daily wagers. These writ petitions were dismissed on the ground that no ad hoc appointments can be made by the commissioner. Later on, they filed a review on the basis that 2 persons had been actually appointed as ad hoc. And these 2 persons were Shyamal Ganguly and Lordships, one was Vimal Kumar Upreti. On the basis of these 2 persons who had been appointed on ad hoc,
They filed a review, and in the review petition, it stood allowed to the extent that since these two persons had been granted ad hoc appointments, these 5 persons would also be, who were the review petitioners, would also be given the benefit, and therefore, if lordships may have page 74, the operative part of the order of 19th May 2004, last paragraph. In the result, the review petition as well as writ petition, insofar as it relates to the review petitioners only, are allowed. A writ in the nature of mandamus is issued commanding opposite parties to appoint review petitioners on the posts of junior clerk, giving them equal treatment which has been given to similarly circumstanced persons, namely Shyamul Ganguly and Vimal Kumar Upre. Lordships. What the state has done, Lordships, immediately thereafter, they filed a contempt petition. During the pendency of the contempt petition, Lordships, on the next page, Lordships may find the order of the contempt petition, where the order has been passed on page 82. They have been granted appointment. Lordships, page 82, Lordships may have. This was the first contempt petition they had filed, in which during this pendency, the appointment has been made. Learned Standing Council states that the order passed by this court has been complied with. This fact is not disputed by the Learned Council of the petitioners. In view of the fact that order passed by this court stands complied with, the contempt petition is dismissed. Now, Lordships, what the state had also taken a remedy was of a special appeal. And these appointments which had been made subject to the outcome of the special appeal. However, Lordships, when the special appeal came to be heard in the year 2017, Lordships may have that order, it starts at page 83. That has been dismissed on the ground that they have been given appointments, and now so many years have passed, it has become infructuous, and therefore on that basis the special leave, the appeals that were filed by the state were dismissed. Now, Lordships, after all of this, Lordships, here also their statement is recorded. Lordships may have on page 83 also. 83, Lordships may allow me. The Honorable Single Judge had allowed the review petition, issued a writ of mandamus commanding opposite parties to appoint the review petitioners on the post of junior clerk, giving them equal treatment which has been given to similarly circumstanced persons, namely so and so. It has been informed that this order has been complied with in the year 2005 itself. It has also been informed that service of review petitioners has been regularized, also by order dated 8th of February 2012. Since then, the review petitioners are working on regularized posts. So, Lordships, they were appointed in the year 2005 on ad hoc, later on regularized, and later on promoted also. There is a seniority list which also came in the year 2011, Lordships. It was not objected to. In para 6 of the rejoinder, state also discussed review petitioners who were regularized have been given next promotion. Lordships, page 84. Also by the order dated 13th of August 2012, this order was made subject to decision of special appeal. We have heard respective councils. Respondents are working since 93. We are in 2007. About 23 years have passed. Service of respondents have also been regularized, but have been given promotion, and seniority list has also been annexed to the rejoinder. Their names have been shown in the seniority list. Court feels that this belated stage, no interference ought to be made with the life and working of the respondent. The special leave appeal has lost its efficacy due to the flux of time. Therefore, it is dismissed. Lordships. This is how, Lordships, this special appeal came to be dismissed. So, the compliance which was made, which was of the appointment, was totally complied with. In fact, Lordships, the contempt petition which they had, the first contempt petition they had filed in the year 2005, they had sought only appointment as ad hoc, Lordships, as equivalent to those 2 persons, which was given to them. And it is a fact, Lordships, that those 2 persons went to Uttarakhand after the division of the state of Uttar Pradesh. So these 2 persons, namely the Shyamul Lordships Ganguly and Vimal Kumar Upre, they went to Uttarakhand. And these persons continued in the state of Uttar Pradesh, Lordships, and as on date, Lordships, they are getting much more higher benefits, which we have stated on affidavit, than those 2 persons. Now, Lordships, what a second contempt petition is coming to be filed, Lordships, which is the impugned order.
Yes.
Lordships. They filed this on 23rd November 2018. It was numbered as 2018 contempt petition, Lordships. a second contempt petition for non-compliance of that 2004 order, Lordships, seeking thereby that those two persons who had been appointed ad hoc in the year 1993 by another writ petition, they had been removed, they had been terminated from that job. They had filed another set of writ petition in which they had got a stay order. And that's by that stay order, they were reappointed. The 10 days gap in their appointment and their termination and their appointment, reappointment, they were granted by an order of 1999, 1/3 salary for those 10 days from the date of their termination in the year 1993 and the date from where the stay order took place. The 10 days happened and the court said that you pay them 1/3 salary for those 10 days. Now, Lordships, here in 2018, after all these 15 years, they come to say that you have not given us 1/3 salary for what period, Lordships, that is not specified. Since earlier to 2005, prior to 2005, they were only working as daily wages from time to time for small periods. They were not in continuous service. They were not in ad hoc service. So there was no time period. There was no direction by this order of 2004 that we have to pay them 1/3 for any specific period. So, Lordships, now in the year 2018, after these two statements made by themselves that the order has been completely complied with, the special appeal also gets dismissed. Now they are seeking that some 1/3 has to be paid to them. Lordships, in fact, in the impugned order, there is an erroneous observation, Lordships. If Lordships may have page 14, para number 14. On careful perusal, page 14 of the impugned order, where the High Court has gone wrong. On careful perusal of the material
Page?
on page 14, not just order. Lordships, page 14, the para on the top, in the middle, Lordships may find on the undertaking that as an appointment. On the undertaking, Lordships has that in para 13 above 14. On the undertaking that as the appointment to the applicant has already been made, other consequential benefits shall also be given. As and when it is calculated, the contempt application was disposed of. Lordship, this is error.
Mr. Prasad, that 1/3 is only the second grievance.
Consequential benefit.
Consequence, main grievance is that whatever Shamal Ganguly and Vimal Kumar Upreti were given, and the date from which they were given has not been given to the petitioners. Additionally, 1/3 salary from the date of termination till date of joining.
Lordships, they were never terminated. They were never joined.
What about consequential benefit?
So, Lordships, the only benefit that they had to get was the appointment. If we see their contempt application, which they
You
had
should have
filed in the
argued
first
that in
round.
the special appeal, which you allowed it to go as infructuous.
Lordships, the appeal was on merits, Lordships, that we cannot make ad hoc appointment. Because that was the original case in the writ petition. The counter affidavit of the state said that we cannot make ad hoc appointment. However, since two persons were found that they had been made an ad hoc appointment in the year 1993, the court held in review that no, you have the power to make a ad hoc appointment. So proceed and make ad hoc appointment. We made that ad hoc appointment from 2005, Lordships. And that has continued. They were confirmed, regularized, promoted, and they have accepted that, Lordships. The fact that they had at all to any some backdate, Lordships, some of them were working as daily wager in the year 1991. Some worked.
What was your grievance, Mr. in the contempt petition? Yes, madam.
I seek your lordship's permission. Please, your lordship. Lordship, have page 84. Our grievance has been considered by the Honorable Division Bench after by Honorable Single Bench in the review petition, which has been read also. Page 84 clearly says respondents are 19 in 2017. Not the disputed fact that we've been working since 1993, and the termination by which the petitioners have been, or herein before your lordships, the respondents have been terminated. is also by the same orders that has been applicable for the Shyamal Ganguly and Vimal Kumar Uparethi. The um, the order, Your Lordship, the review petition order was to give the equal treatment, exact equal treatment that was given to Shyamal Ganguly and Vimal Kumar Uparethi because they were terminated. So, Your Lordship, the termination order was for 10 people. That was challenged first by the respondents herein before Your Lordships. The orders were not in their favor. Then two other people have approached the Honorable Single Judge, and a detailed order was passed quashing
What is your grievance?
that very termination order. Your
No,
Lordship, my
actually,
grievance is, your Lordship, my grievance is that the equal treatment, because Your Lordship, they had appointed us in the year, calculatively, they have appointed us in the year 2005, wherein
You read your content
so,
petition from page 86. The present content petition.
yes, Your Lordship, I have it.
Is also there on page 77.
Hmm?
The earlier contempt.
No, we are only concerned with the present one.
Lordships, although what they had pressed in their first contempt would also be looked into, Lordships. Page 79, para 9, Lordships. They were only seeking appointment. Page 79, para 9. And Lordships, my learned friend here is submitting that they had sought some challenge, some termination order, Lordships. We did not find such a writ petition.
Your Lordship, page 87 of my contempt petition, clearly after quoting after quoting the decision of the Honorable Single Judge, wherein the equal treatment which has been given due to the similarly circumstanced persons, namely Shyamal Ganguly and Vimal Kumar Uparethi. Your Lordship, now para 5 clearly says that in view of this, it is the duty of opposite parties firstly to appoint the review petitioner on the post of junior clerk, and secondly, it is required that they shall be given equal treatment. And Your Lordship, the equal treatment that has been given a very less significance herein by my learned senior, that 1/3 salary of only 10 days, which is not the case, Your Lordship. It is not the 10 days salary, Your Lordship. They had given us the appointment in the year 2005. Calculatively, because there were different rules in the year 2004. Those rules are applicable now upon the respondents herein before Your Lordship.
What is the contempt according to you?
Your Lordship, the contempt is that just to Your Lordship, 2004, when we have filed the contempt petition, the initial contempt petition was not only in regard to the appointment of the respondents, but was also in regard to everything, because the termination order
You are
was
not
same.
specified in your contempt as to what is that
Everything is, Your
everything.
Lordship, 1/3 salary benefit, Your Lordship, as is given to Shyamal Ganguly and Vimal Kumar Uparethi, Your Lordship. Because we were the daily wages for us, the 1/3 salary also plays an extreme significant role.
There is no specific averment as to what part of the order they are not implemented.
Your Lordship, in 1/3 salary part, they have mentioned, Your Lordship. I'll place that also. Your Lordship, but with all due respect, Your Lordship, but this has already
you have seen
been...
that in view of this, the contempt of the appointed, the applicant. What is that
Your
last
Lordship
part of the order?
Your Lordship may just...
As per this order, you were entitled to get this and this, which is denied to
Your
you.
Lordship, the order date is mentioned, that is 19/5/2004, and the 19/5/2004 mentions the order has been passed in the case of Shyamal Ganguly and Vimal Kumar Uparethi, which discusses everything, Your Lordship. Now, and with all due respect, Your Lordship, all this has been argued. Your Lordship may have Your Lordship's order of 27/9/2023 for a moment, Your Lordship. 27/9/2023. In this very SLP, Your Lordship, that has been passed by Your Lordships. That clearly says, Your Lordship, wherein the petitioners were directed to file an affidavit, filing an affidavit indicating that whether the 19/5/2000, because why I'm pointing out this order of Your Lordships is because this has all been argued before Your Lordships, wherein Your Lordships had observed that 19/5/2004 stands fully complied with, wherein after hearing the petitioners in this very SLP, Your Lordships had been pleased to observe whether it has been fully complied, Your Lordship, because this has been argued, therefore I'm reiterating myself. Now, Your Lordship may have para 7 of their counter that they have, of their rejoinder that they have filed. Compliance affidavit, rather.
It's called additional affidavit.
Additional, I am sorry, Your Lordship, additional affidavit. Wherein they themselves are accepting this fact, this very fact, as to why they could not have complied with the part of the order. If I may be permitted to read, Your Lordship, that it is worth mentioning that Sri Ajay Verma, who is the respondent before Your Lordship, and others were never appointed on ad hoc basis and have not remained in employment prior to 28/9/2005, except for a small period of daily wages. Hence, they are not entitled of 1/3 of salary during the period of unemployment. Your Lordship, that means they are accepting the very fact that that is why they could not have complied with the orders that have been passed by the Honorable Single Judge, order dated 19/5/2004. Your Lordship, now opening the merits of the matter before Your Lordships, after the matter has attained finality, right? And Your Lordship, they had filed an SLP before Your Lordships in the year 2019. That has not been discussed in anywhere. Therefore, I had taken this ground also in my rejoinder that they have not approached before Your Lordship with the clean hands, because in the year 2019 also, whenever this petition is opened, whenever the contempt petition before the Honorable Single Judge is opened and any charge framing orders are passed, it is the practice that they approach Your Lordships and they pray for staying the contempt petition, because in the year 2019 also an interim application was filed before Your Lordships staying the contempt petition, and this very contempt petition of the year 2018, because that time also, in the year 2018 also, Honorable Single Judge, after considering everything in detail, has passed charge framing order. And merely by filing an SLP 2018 also, the petition was stayed before the Honorable High Court here in Lucknow. Now, Your Lordship, after that SLP in the year 2019, which actually challenged the special appeal order, got dismissed. Therefore, that means the matter has attained finality, because right up to the SLP, the equal treatment benefit has been settled. Equal treatment benefit, now, Your Lordship, everybody understands equal treatment benefit. What does it indicate?
At page 7, you are comparing as to how Ganguly is different from Ajay Verma.
Your Lordship, additional affidavit, page 7.
Now, what they are claiming is of the 1/3. We are showing that they were actually appointed in the year 1993. And therefore, they were terminated at for some point of time. Then they got a stay, and there was a 10-day gap. Now, these persons are appointed in the year 2005. Lordships, they have not claimed that they want an appointment since 1993 till 2005. 2005 was their ad hoc appointment. Now, for that 10, they were never.
According to you, what is not paid to you, madam?
1/3 salary, Your Lordship, as it was paid
how
to
many
Mr.
days?
Ganguly and Uparethi.
For which period?
Your Lordship, from 1993 till 2005, when we have been, it is not 10 days salary, Your Lordship. It has been.
Were you working during that period?
Your Lordship, we were not given appointment
Were you
calculatively.
working or not working?
Lordship, we were terminated. We were just babus of their department, wage workers. We were not made to work anywhere, because we have been terminated. And because the petition was pending before the Honorable High Court, therefore, we were just
Then
pursuing our case.
The pay fixation, insofar as you and Shamal are concerned, is it the same?
Your Lordship, but the termination
Yes or no?
order is same.
Yes or no?
If Your Lordship, I bow down to Your Lordship's observation,
Please answer the
but Your
question,
Lordship may understand this. Yes, Your Lordship, but Your Lordship may hear me. Your Lordship, the liability cannot be attributed to the respondents. It is about the liability also. The liability cannot be, if they are not appointing us, we are made to
Please
run
answer
from
the
pillar
question
to
whether
post
the
to
pay
the
fixation, insofar as Shamal and you is concerned, it is same or different?
Your Lordship, it's the same if would have been given appointment right after the decision passed by the Honorable High Court quashing the termination order. If right after it would have been same because 2004
The petitioner challenge, the order dated 10th of May 2023, by which the learned single judge of the High Court has framed the charges against the petitioners. First, the grievance of the
Found
petitioner
guilty and directed listing for coming charge.
has found contempt guilty and framed the charges against the paragraph. The grievance of the petitioner is with regard to non-compliance of the directions issued by this court dated 19th of May 2004. By the said order, the learned single judge of the High Court had directed the petitioners therein to be given the same treatment as that has been given to Shamlal Ganguly and Vimal Kumar Upriti. Paragraph. Alleging non-compliance of the said, the petitioners had filed contempt before contempt number 2285 of 2004. The said contempt petition was dismissed when the state pointed out to the notice of the court that the appointment orders were already issued in favor of the petitioner and their services were also appointment orders were already issued to the paragraph. The contempt petition was therefore dismissed. Paragraph. The order dated 19th of May 2004 was also challenged by the state by way of special appeal number 173 of 2005. In the said appeal, the division bench specifically recorded that the services of the respondent were not only regularized, but they were also given promotions. First of paragraph. The present contempt petition. Paragraph. It appears that thereafter, after a lapse of considerable period, second contempt petition were filed alleging non-compliance of the order dated 19th of May 2004. First, in the said petition, the High Court found that the salary which was granted to Shamal Ganguly and Vimal Kumar Uperi from 1993 till the date of fresh appointment was not granted to them. Hence, the petitioners were contempt of the order passed by the High Court. Paragraph. To a specific query to the learned counsel of the petitioner as to whether, to the learned counsel of the respondent as to whether pay fixation in their case is on the similar lines with that of Shamal Ganguly and Vimal Kumar Upriti or not. The learned counsel fairly states that it is on the same basis. Paragraph. In that view of the matter, we find that entertaining the second contempt petition for the same cause of action. When the first contempt petition was disposed of, was in that way, we find that the High Court has erred in entertaining a second contempt petition for the same cause of action, in respect of which the rear contempt petition was already disposed of. On the short ground alone, the appeal is allowed. The impugn order as well as the contempt impugn order is quashed and set aside. The contempt petitions filed before the High Court are dismissed.
Most cases, Lordships, they are at no difficulty, Lordships, but the chart that we have shown, in fact, shows that where those people were promoted in the year 2018, he was promoted in the year 2012 itself. Lordships, there is no prejudice.
Visit order.
But the matter pertains to the implementation of the provisions of the National Commission for Allied and Healthcare Professionals Act. My lords, if I may just give a brief background, my lord, the doctors have medical council, dentists have dental council, and nurses have nursing council. The other healthcare service providers, my lord, they did not have any regulator. Because of the absence of a regulator, my lord, this sector remained all throughout unrecognized, and this people are commonly called as, my lord, the allied healthcare workforce. If I may give an example, my lord, they are the medical laboratory technologists, my lord, who take the blood, who test the blood, the X-ray technicians, the dialysis technicians, my lords. So the list goes on, my lord. The center has identified about 57 professionals who belong to the allied healthcare sector. My lords.
Yes.
Milords, this sector, milords, always remained unrecognized, and milord, the basic standards of education or the minimum qualification which is required to become a professional of this allied category was not even uniform, and it is not even recognized. Person from 3 months diploma to a 4-year degree course, a person can get this qualification. The demand had been raised, milord, by these professionals.
What happened for the
attorney has been done.
Milords, if I may just submit, milords.
Without them, we can't hear the matter.
Yes.
We are appealing for the union. We should say that.
Milords, I just want to tell my lordships that the
how can we hear the matter without ASG? Because what is the stand of the union? That is important.
Milords, that's what I'm submitting. I have no difficulty, milords. That's what I'm submitting. An order was passed on 12th of August.
You have seen that order, yes.
Yes, milord, that order is not complied with as per the counter submitted by the union. That's what I just wanted to submit, my lordship. That order is not complied with, milord.
Therefore, will it not be necessary to hear them?
Yes. Milords, the difficulty is that, milords, my lordships had directed 2 months' time for them to form the institutions. Milord, till date, even the National Commission is not fully constituted.
But you can't. For the executive, for the legislature.
Yes, milords.
To what extent the court should interfere in all these matters?
My lords had already directed in the last order.
We have seen that order.
Yes, my lords, that order is not complied with at all. My lords, even the states have not formed the state councils. The center has not formed the National Commission also. That is the difficulty. My lord,
let the ASG come.
My lords, may kindly accommodate us with a short. My lord, the entire sector, my lord, this has been a long-standing demand.
Who are you?
My lords, I am an association of these professionals, my lords. My lord, we have been fighting all throughout these years, and it was recognized in 2021 with the passing of an act. My lord, till date, my lords, it is not implemented, my lord. My lordship's order is there.
What is your condition in the affidavit? What is the compliance of the order according to you?
Go to an extra 13, page 135, 185.
the details are given from para 6 of the counter affidavit, where they admit that they have not formed, even the National Commission is not formed. The nominations are taken. They are just at there. Even the vice chairman is not appointed so far. Ex officio members who have only the joint secretaries working with Government of India, even they are not appointed, my lords. The states have not formed the councils, the rules are not framed. My lordships, I directed them to do the needful in 2 months' time. The lordships may have para 6 of the counter, my lords.
Reply of Union of India? Union's reply,
Union's reply, my lords, page filed on 12th of November.
Page,
My lords, if your lordships may have, my lords.
Page 7, 8.
Page number 7, my lords. Where they say, my lords, as per section 3, a national commission is required to be formed. The national commission comprised of 47 members. For the commission to act, minimum 24 members are required. Out of them, 25 are government nominees. Even those, that number has also not reached. Because of this, the 10 professional councils which are required to be formed as per section 10, that is not formed. Because of this, the regulations which provide for the basic standards of this profession, the education which is required, that is also not framed. The states also, my lord, the center has filing the reply in respect of the states. Only 21 states have formed the councils. And only 5 states have framed the rules. Whereas the requirement of the act is that first you have to frame the rules and then you have to form the council. Only 3 states have complied with the provisions of the act in full. They have formed the council, they have framed the rules. That is the difficulty. Only 3 states, Maharashtra, Andhra and Kerala, have framed the rules and formed the council. None of the other states have complied. The center has not even formed the National Commission in full. That is the difficulty, my lord, which we are facing.
check the time by January, pursuant to the.
My lords, Ritesh Sri Haravar, rules as mandated under NCPCR have been notified 27/5/2021. Not being held by laws, but the rules have been.
Have you set up the state councils, the state set up councils as a union set up
Union has set up a council.
national? See the order.
AG की तो उसको कुछ आएगा.
1 and 22 of the counter affidavit filed by Union, they have stated that the 13 states and UT, they have already framed the rules and that details are there, and 23 states and UT have given the name. They have mentioned about the 23 states and UTs.
Lord, section 68 says that states have to first frame the rules. Only 10 states have framed the rules. Only on the basis of the rules the councils can be set up, because these rules provide for the minimum qualification which a member should carry. Only 10 states so far have framed the rules, my lords. The others 21 states which have formed the councils have formed it without even framing the rules. Just for paper formality, my lord, they framed the councils without framing, they formed the councils without framing the rules. The center has to first constitute the commission first. The 11 members who constitute members of the commission are ex officio members of the government. They are of the ranks of joint secretary. Even till date, my lords, till it's been more than 3 years, they are saying that they have only received the nomination.
Who has not framed rules?
Please, my lords.
Who has framed rules, appointed council?
Please, my lords. Oblige, my lords. Please.
I'm seeking time to file a rejoinder lordships. We need to place on record the site plans of that area lordships permit us. 2 weeks time lordships for the rejoinder.
It's a very short issue, Lord. They have to issue me a sanction plan, Lord.
It's not a, it's an old issue, Lord, it's more than 30 years.
Every
and that entire
law
name
in
is
that
had-
stretch is bailed, sanction plan given. It's only for me, Lord. They're not giving me sanction plan. The order is simply either you acquire it or give me sanction plan.
This is
They
why,
can't
Lord,
have
we
a
need to
sanction
find a
plan.
rejoinder. When he says that only his case, Lord, we need to show the entire road, Lord.
Till now, all orders in my favor, not even a single case they have shown who did not get sanction plan. It's only my plot that they're not giving sanction plan.
Therefore, permit me.
All orders have been against them.
All orders are against you.
Lordship, since what they have been doing is the misleading, which again they have done in the counter affidavit.
So the court is,
Therefore, Lordships, we are seeking just one opportunity. I will show Lordships what is the situation, what the DDA master plan says. The MCD cannot go beyond that, Lordship. So we are bona fide. We just need to show that to my Lords. Lordships will grant me this
Public sector, I think.
opportunity to go on in detail about this order and this entire case, Lordships. This is the case near the Gangaram.
no, but you have lost before the ATMDC, then the district and session judge.
Yes, Lord.
Then,
I will show and Lordships, I'll try to convince my Lords. Why
You do it
this-
now. You can't go beyond.
We need to place on record.
No, you can't go beyond the record of the High Court.
Lordships, there's only a presentation of that place and the master plan which is already there, Lordships, it is a public document. I will not be placing on record any additional document, Lordships. As per the master plan, as per the DDA directives, Lordships, the MCD has to proceed. We cannot give them a sanction for a building which is now for a road, Lordships, which DDA has earmarked for an expansion of the road. And therefore, Lordships, how can MCD allow a mall
Then
there?
pay them compensation.
Lordships, that is where Lordships, the DDA has to respond to that, and we will place on record the master plan of Delhi, Lordships, what was there in the year 1990 and what was there in 2021. I'll just place on record those plans and maps. Allow me, Lordships,
public sector.
one opportunity.
Yes, Manoj.
I will just, Lordships may allow me this one opportunity. I will place that on record. If Lordships is not convinced, Lordships, we are in Lordships' hand.
You will make it the interim relief.
Lordships, it is not so, it was a contempt.
And
Lordships,
Manoj, if DDA
what is
wants
the
to do
issue?
anything,
Lordships,
they
that is the-
acquire it as and when they acquire it. They have, Manoj.
You just have to sanction the, if the, tomorrow DDA wants it for road widening or something.
Lordships, what the DDA does, Lordships, it has its master plan. It has made a master plan showing an expansion of that road. And that is a road at Gangaram Hospital, Lordships. It is a flyover. It goes to Patel Road. The entire road of for more than 4 kilometers, the expansion plan is there.
So take the land and pay the compensation.
So, Lordships, that is for DDA to take a call, Lordships. We are in no difficulty. We are in Lordships' hand. We have to go only as per the directives of DDA, Lordships. Beyond that, we also, Lordships, are unable to proceed, and therefore, Lordships, it is our humble request. I will just show, Lordships, what they are saying, that in series of properties, this plan has been imposed, Lordships. That sanction.
So they must be all private individuals. They might not be.
Sanctioned, my lords, plot
They
10
are
on the
parks.
same road, they sanctioned, plot 13 is mine, that they are not.
Knowing that this sanction.
They must not be possessing that expertise which those private individuals are possessing expertise.
They have, Lordships, they have purchased this property knowing that this sanction has been rejected since the year 1993-94, not Lordships. And therefore, Lordships, what the DDA brought, that change, Lordships, it's brought in the year 1994.
They are not an individual. They are not an individual.
Lordships, they have purchased this land from individuals.
They are not an individual.
Lordships, they have purchased this land and now they are trying to build a mall over it, Lordships. Lordships, will just permit me.
Our own office premises, Manoj, not a mall.
As
not
on today, Lordships, there is a residential house there. Lordships, will permit me, I am just seeking one opportunity.
2 weeks by a last chance. Specific date. Yes, Mr. Mitra.
Matter relating to the discrimination between allopathic doctors. Just permit me to give a few facts. By an ordinance dated 20th of June 2019, you know, get it at page 75. The state of Telangana enhanced the age of superannuation from 58 to 65 years in respect to the doctors working in allopathic stream and dental colleges. And kindly see the reason that is assigned. Page 75. And please look at page 76. See paragraph 4 at page 76. And whereas besides non-filling of functional faculties arose due to retirement, promotion of doctors also have not been taken up in time.
You are reading, and whereas?
I am reading paragraph 4 of page 76.
Yes, please.
And whereas besides non-filling of teaching faculties arose due to retirement, promotion of doctors also have not been taken up in time, leading to huge shortfall of teaching faculty, particularly senior teaching faculty in the cadres of professors, associate professors, and assistant professors. Whereas several new medical colleges have been started in the recent past, government also contemplating to start new colleges, and because of this, they have enhanced the age of superannuation from 58 to 65. Then, the doctors working in the Irish doctors, they made a representation to the government, one after the other. You could find it at page 73, 79, 88. And then they filed a writ petition before the High Court. The government directed that it should be considered. Then, the second ordinance was issued by the state government. At page 88, you could find it. This is dated 31st of July, And please see, the very same reasons have been assigned at page 89. '88 is the ordinance, and page 89, very same reasons. Paragraph 3. And whereas due to various constraints such as resultant vacancies due to retirements could not be filled up by the government, leading to shortfall of teaching faculty, particularly senior teaching faculty, which is adversely affecting the medical education government Irish medical colleges as well as patient care. Whereas Central Council of Indian Medical and the Central Council of Homeopathy during their annual inspections raised the issue, and the recognition to these colleges is given on conditional basis, subject to making the earliest. So the reasons that are assigned for enhancing the age of superannuation of allopathic doctors, they have followed it in respect of Irish doctors also, and ordinance was issued on 31/7/2020. Now the grievance is only in respect of the Irish doctors who retired between 20th of June 2019 to 31st of July 2020.
20th of June?
20th of June 2019. And 31st of July 2020. And the petitioners before your lordships are those professors and associate professors who retired between these dates. Now, your lordships in this court I've already taken a decision below the judgment of your lordships at page 43. Your lordship could find it.
Justice Rishikesh Raj.
Page 43.
Justice Rishikesh Raj.
Let's page 43.
Justice Raj judgment.
Dr. Ramnaresh Sharma and others. And this court recorded a finding that there cannot be any discrimination.
Yes, but now all of you must be above 65 now.
Even take it 2019 as the basis of our retirement, it is not even 5 years. Still have 2 years of service. And the matter was heard by your lordships on the last occasion. The contention that was raised is, since they have retired, they can't be put back into service. That's what your lordships asked me to do. And then,
At the most, they will not be entitled to the salary during the.
That's from 2020 onwards to this day, 4 years. All the vacancies have been filled, many promotions have been effected. There are single posts as well, such as principals, etc. If anything were to happen, they should be brought back, then it will have that cascading effect. Most of them are not before your lordships, or before the Honorable High Court. And of course, apart from the merits, the practical difficulties.
How many are there in your category, Mr. Rao?
there are hardly about 15 people who are the petitioners before the High Court.
At the higher echelons, at the ranks of principals, professors, etc.
These kind of administrative chaos is a thing that was rejected by your lordships in this court in 1985 itself.
In Naresh's case, which my learned friend is placing reliance, by virtue of interim orders, they never continue. Here, they have superannuation from earlier rules. Thereafter, in 20, came. Now they're all 5 years down the line. Some of them are principals. They can't now. And they service your lordships. And this court not one in so many instances of it. This is a purely policy decision. Parity has been made.
No, but there is a direct judgment by Justice Roy.
Naresh's judgment that by way of people service for 5 years salary. So when the that will not fancy the subject matter that and this court salaries and because they never
For 7 years. Last round salary.
and they've not worked.
Now on hold on the.
Everything they did.
No, I'm not saying. They are giving you pension as a 58 retiree.
Yes. Now because they retired me from service.
It's no fault of theirs. Somebody has gone and held up the file so that.
Another annulment.
That's
the
what-
perspective is there, minutes.
Similar is the case which your lordships are considered in a 3-day judgment. Kindly have a look at this judgment 85 supplement SCCs. It is also a case arising from Andhra Pradesh.
Nagaraja.
No, Millard, this is Prabhakar Rao.
Prabhakar Rao.
Same is the question. There the age of retirement was initially reduced and then it was enhanced. What happens to the people who retired in between? Kindly have a look at page 459. Millard. Immediately after the extract in that page, the court then asked
Page
459.
Yes.
Please see immediately after the extract, Miller. The court then asked itself the question, by our approach, are we making the scheme retroactive? The answer was emphatic no, they said. Then after quoting this, kindly see the next. The court finally considered the favorite argument advanced whereas some of the counsel who appeared before us described as judicial tinkering with the legislative policy. The court took the view that the state cannot say take it or leave it. If these words are in a statute which bring about discrimination, these words can be severe. Then after quoting from the judgment, then please, this is the very same argument that which advanced that it will create chaos. Kindly look at paragraph 20 of the judgment. In the course of our narration, we have already stated our conclusions on several questions at issue, both factual and legal. The final situation emergency is almost immediately after the age of superannuation was reduced from 58 to 55 years, it was realized that the government of Andhra Pradesh that they have taken a step in wrong direction and the serious wrong and grave injustice.
That reduction was Nagaraj, K. Nagaraj.
Yes, despite the fact the reduction in age of superannuation was upheld by this court. And those persons were allowed to retire. Subsequently, when the government has enhanced and 32 petitions were filed before your lordships. Your lordship said that even those persons who have retired are entitled for reinstatement if they are within the period. And those who have retired, in the case they have retired, they should be given salaries also. That's what your lordship said. Particularly where a decision is challenged on the ground of.
For the state.
Well, I appear for one of the candidates who get affected because I'm in service.
Please,
Well, also, I'll appreciate one simple thing, minutes. This judgment actually in my favor. I'll explain that minute, that apart. Let me submit this minutes. The learned single judge
We are
has
asking the
laid out
state.
Ram Naresh.
We are asking the state to take instructions whether they can be accommodated. There are only 15 of them. They will not be entitled to any salary for the period during which they have not worked. You take them and they will retire at the age of 65. Not 4 weeks, 2 weeks. No, so they will join as teachers. We will say that no status quo would be disturbed. Yes, we don't want to. No status quo, whatever. They will not be entitled for any salary for the period which they have not worked.
Nor will they displace those who have been.
Nor will they displace. And they will work so that at least they retire at the age of 65 and their pensionary advantages would be more.
Yes, let them take
7 years. Even otherwise, Millard, the persons who are juniors who have occupied our places, even after the extended age of superannuation, and after we retire at 65, they will have these again the same extended age. It is
We have
not
already
as if
had
I'm
it.
sitting on
We have
your
already
head.
had it. It is you who missed the bus, obviously. Yes. Yes.
Accelerate. And Millard, the High Court said that you are not even entitled to be implemented. High Court rejected their
Millets,
application for
if the
implementation.
state comes out with an answer, absolutely no issue, Millets. But interestingly, Millets, my lords could see half a dozen judgments this side and half a dozen judgments that side. Perhaps my lords may have to settle if it doesn't come to the hustings.
Naresh is different, your lordship. In fact, Naresh considers the.
But let them get instructions, Millets, my lords could see.
Council appearing on behalf of the state. Take instructions as to whether petitioners who are 15.
Only 7.
No, how many are here?
7 are here. I say the whole list is 15, but 7 are here.
We will only go for 7. As to whether the petitioners who are only 7 in number could be accommodated so that their services could be utilized till they attain the age of 65 years.
Without disturbing the existing.
Let them come with the answer.
Please dictate. Stand out 2 weeks.
Great. Let's have 8 minutes so that.
Specific date there.
Well, it's an item 46 notice may have to go. It's been.
Along with this. 46 is with this.
46.
Their SLP Millard where the High Court rejected the application for.
Saying that I have no locus minutes, I am affected for
Saying
that.
that they have no.
Notice legal.
Great.
This is for suspension of sentence, my lord, pending the appeal. 2 years and 4 months, my lord, he has undergone out of 6. My lord, in January, my lord granted me liberty to renew the request in case he is not heard in 6 months, my lord. Another 1 year has passed, my lord.
Who is appearing for the state?
We are appearing for the state.
He has already undergone more than 50% now.
That is 40%.
50%.
Around 50.
Last occasion, 13th of November, the date was showing, but it was not in the list. And now, my lord, there is no next date, my lord. On the case status, I took out the printout this morning only.
Take instructions. I will file a reply.
Earlier they had filed or?
File counter. File your counter because now he has almost suffered 40%.
SLP they had filed the counter.
What is the stage of the appeal?
After notice, my lord, so
Appeal.
after notice, my lord,
No, the appeal before the High Court.
so 13th of November, my lord, was the last date being shown, but it was not in the list. Now there is no next date, my lord, as per the case status.
Take instructions within 2 weeks. The learned counsel of the state to take instructions. Stand to 2 weeks.
My lords, if I may, I am in the connected item 19.3 on behalf of the petitioners. The arguing counsel owing to personal difficulties is unavailable. So we are seeking a short accommodation of 1 week's time. We've already informed the officer. Sorry. And
Because there were batch of matters, so therefore I am present. I knew about their seeking an adjournment, but the similar issues arising in other matters.
When do you want? 2 weeks?
no, but just 1 week's time.
1 week.
Next week. And if I may be permitted to make a request, the most contemporaneous matter in this batch of petitions is 19.3, that's filed against the 2024 NEET PG examination. If that may be read as the main matter at the next hearing, if your lordship.
That you decide amongst yourselves.
That is the
Convenience.
29 point?
19.3.
19.3.
19.3.
That's a main matter. We read this matter.
Yes, that's
Yes.
right.
Mr. Acharya, Ishika Jain. Again.
That is for this session.
Yes, that's the only matter. which is-
Others are for the earlier session.
And-
उसको number एक बता दीजिए. Lead matter करके बता.
Item 19.
Yes.
Because the larger issue with respect to transparency, which is raised the counter and the rejoinder, everything is filed in that matter.
Oh, I see.
We don't have difficulty because that can be the main
The
matter.
transparency has also been raised in Shika Jain as well, so.
But
whatever-
It's not so much that the facts are in dispute. It's the method by which the examination has been carried out by the examination body, because that is what they are challenging.
Okay. You are for the?
I appear for National Board of Examination, we conduct the examination for NEET PG.
Next week.
Tuesday.
Item 20.
Please,
Pertains to the state is appealing the order quashing the judge.
Second. Oh, देखो मैं मिसाल आ गया करके.